big warm welcome back to the channel, and today I have a special guest for you. I have Andrea Burkhardt with us today. How are you doing, Andrea?
I'm doing great. It's so nice to finally meet you over video.
Likewise. So most of you should know by now, Andrea instigated the unsealing and the revealing of all the documents. So everybody now has access to those documents thanks to Andrea. But before we get too much into that, just a little bit about yourself for those that are not familiar with who you are and what brought you to YouTube.
Sure. Well, so I'm a practicing attorney in Washington State. I've been primarily a criminal defense attorney for, gosh, I guess it's about 16 years now, 15 or 16 years. And so I became interested in the Johnny Depp trial shortly before you folks had your trial over there in the UK. Once I started to see some of the witness statements and things like that were coming out, it really caught my attention because if you had just relied on the media, you would have thought that it was a pretty one-sided story. And so starting to hear the other side of the story was certainly interesting, but more to the point from my perspective, because of how our defamation laws work in the United States, it's such a rare occurrence to see a public figure defamation claim actually go forward to trial. Mm-hmm. And so once I began to see what the evidence was going to be, it became clear that it was going to survive those hurdles here. And so we were going to have the proceeding that we all just went through. So I knew that it was going to be a rare occurrence and something I wanted to be attuned to.
Absolutely. And interesting point that you make is that people can often be swayed by the media because the media can often seem one-sided. Now, I've done a video about this before that I'm sure it's the same in the States, certainly in England and Wales. Court reporting has to be fair and impartial, not casting opinions on what's been said in court. It has to be fair and accurate reporting of what is said in court. And news outlets are deemed to have the permission to do that without seeking permission of the court. Members of the public would have to seek permission to do that, and that happens. And what I've seen recently, in some cases which I'll talk about in a few days probably, are that newspapers take very often an opening speech and report it, or they take the evidence in chief, the primary evidence of a witness, and report it, but then they don't necessarily report much else. So in one sense, that gives a one-sided view of what's going on. But of course, that's only half the story. It's fair and accurate in terms of what's reported, but it's not necessarily the full story. And you're right as well in saying that this trial has been so public and so visible, literally broadcast to the world for everybody to see. What wasn't broadcast, of course, is anything that was sealed and thus not evidence. And so before we get too far ahead into that, what I want to do is make sure that we plug your channel and say that if you are not already subscribed, you absolutely must. If you are interested in this trial and these discussions in any way or form, you must go over and subscribe there. The channel is linked in the description. It's the same handle for YouTube and for Twitter. So please make sure you do that. The links are in the description. Before, just as we move into those documents, I did a video earlier today which I talked about. This is an application notice you see here. It's the application in part to adduce additional evidence in the form of a witness statement of Jennifer Howell. And this, of course, was refused by the Court of Appeal. Here is the refusal of that here to refuse permission to adduce this further evidence and refused the permission to appeal. This was in the UK trial. So an important point here, because this will tie up the understanding of what Andrea is about to talk to you about in just a moment, is that this was to bring in a witness statement, which was drafted. I have a copy of that, which very broadly mirrors the next document I'm going to show you. But this was to bring in this witness statement as additional evidence for the appeal. But as I said, that was refused. This broadly mirrored this declaration here, which as Andrea said earlier, if you were to read the news headlines, you would think, or you might think, that this is evidence of what happened and draw your conclusions. If you want a fuller detail as to what this actually says, you can watch my video from earlier today. I'll link that in the description as well. If I forget, someone tell me, because I always forget. But with that, I know, Andrea, you wanted to say a few things about what these documents are and what they mean. And so first of all, even before you do that, what was it, as obvious as it might sound, what was it that drew you to push to get hold of all of these documents?
Well, it's mainly been the need for transparency about the court process and the ability for folks who have the expertise and understanding of court processes to be able to analyze and interpret them in a meaningful way. One of the things that's been a common complaint that I've had certainly for many, many years, and I think it's been widely shared, is just that from my perspective, the quality of legal journalism is extremely poor. It's very rare to be able to find coverage of, just take a high profile case, like, for example, the Ghislaine Maxwell trial, or, just the George, Derek Chauvin trial. I mean, some of these ones that have been very recently headline grabbers. And it's almost endemic to find misinterpretations of the process, misunderstandings of what is happening, what the significance is. And so these sealed documents are intended to be a way for ordinary people to be able to, number one, see for themselves so that they can fact check the information that they're being provided by these sources, but also to enable the independent folks like you and me and many of the other lawyers who are on social media engaging with this case to be able to provide their insights and hopefully act as a check on some of that misinformation that's unfortunately rampant.
Exactly right. And some people, I was about to say many, but I don't think it's probably many. I think some people might not yet still know that you acquired the funds from interested parties who essentially crowdfunded the fees to get these sent to you.
So we crowdfunded this through social media. There were a number of folks involved in that undertaking. A lot of folks who shared, a lot of folks who donated. We raised the funds to acquire these documents very quickly. I mean, within a matter of a couple of hours. So then there were surplus funds that continued to roll in. So we did donate excess funds to Children's Hospital of Los Angeles and Art of Elysium. So that was a wonderful opportunity to be able to help those organizations that had been kind of pulled into the fray to some extent as a result of this case.
Absolutely.
So that was very gratifying to see how many people are interested in the truth and not just accepting whatever line is being fed them by a media outlet or a pundit.
No, absolutely, and that's really fantastic. And if it doesn't go without saying, a huge well done, not just for raising the funds to get the documents so that everyone can see them and it's transparent, but the surplus as well, supporting those organizations, is just fantastic. So I think everyone owes you a big well done for that. And of course, to everybody that donated, it's just so fantastic. And I think what comes out of all of that is, as you say, the transparency, because so many of the comments that I've gone through give the view that this is such a private and closed off type of proceeding. Although this was a defamation case, the underlying issues behind it, of course, without saying too many of the words associated for YouTube, but they are generally all in private, and people feel that because it's in private, they often feel that it's unfair. And I think, as a lawyer, I think I can go on a limb to say that I've seen some unfair processes that I just felt was the wrong call, the wrong decision, and ultimately I've believed somebody when the decision's gone against them. Have you had that as well in your practice?
Oh, absolutely. I mean, I think that's relatively common for folks who are in the trenches doing the trial work. We do our best to get the fairest outcome, but trials can be a bit wild, and things can happen that are unexpected. Um, I think one of the I don't know if it's a huge cultural difference, but
Hmm.
I mean it's certainly there to some extent, just because we saw it in this in these two trials as well. How in the UK certain parts of the proceedings were closed, were
Hmm.
held confidential, and were not released to the public,
Hmm.
whereas in the United States, by and large, our tradition, I mean, we have constitutionally, written that people enjoy the right to a public trial.
Hmm.
So over here, we just, I think, have more of a tradition of the presumption being that things are going to be open to the public. They are going to be open to inspection. We want to see how our courts are doing, how our judges are performing, how our juries are performing, making sure that the processes are operating the way that they are supposed to, that we intend for them to, and that we expect them to. And so that's part of the process of this unsealing as well. Is it's revealing to some extent how the sausage is made. Quite a few of these documents are dealing with essentially proffers of evidence or arguments about what evidence might be brought forward, arguments that might be forwarded,
Hmm.
things along those lines. And so those things are often litigated ahead of time, so that you're not having those conversations in front of the jury where it would be inappropriate. Um, but so the result of that then is you have a bigger picture of not just what was actually introduced in the trial, but some of the things that didn't necessarily make it in, and the reasons for that. And so this, I think, is important, not just in that auditing type of process that we expect, that we allow the public to engage in with our justice system, but also in light of the fact that we did see Amber Heard and her attorney, going on this kind of
Hmm.
media tour, making statements that tended to impugn the fairness of the process and
Hmm.
suggest that there were things that they were not allowed to present unfairly. And so for us to have the opportunity to inspect those arguments and evaluate them is a
Hmm.
very important part of essentially understanding whether we can trust our justice system to produce a fair result or not. If those decisions were unfair, that is something that we would want to know and potentially take steps to correct. But on the other hand, if these types of arguments are sour grapes, that's something that we should have the ability to evaluate as well.
Absolutely. And I think it's a really important point that you make there, because to see those arguments that were sealed, were private, were not heard by the jury, not heard by anybody as such, but to see whether those were fair arguments, or, as you say, sour grapes. And it's not outrageous to think that there's going to be some sort of far-fetched argument for some evidence which doesn't make it in, but some of them might be a really key piece that
Mhm.
people do need to understand. And I don't think I'm being too critical of the general population to say most people probably won't understand a lot of these legal arguments there. You can read through and maybe get a gist of what's happening and the arguments, because there are transcripts, of course, of all these motions in there as well. But again, as I say, so many people will not understand what the arguments are, what they mean, whether they were fair. And so it's thanks to, I'm not going to blow any trumpets, but it's thanks to the lawyers on YouTube to break down this, to explain it. But that's why I wanted you on here to plug your channel, to make sure people subscribe to you, because whilst I am here, England and Wales, and I often say lots of the law is international and universal, and there's principles of law which should, not necessarily do, but should traverse the world in one state. But since you practice there, and there are bits that you can explain that perhaps I can't, so do go and subscribe if you can. So moving back to the documents then, where did you start? There's 6,000, whatever it is, 6,600 pages. One of these documents has got over 1,000 pages that I've just been looking at. Where did you start with all of this? What were you most interested in looking at?
Well, I was definitely most interested in looking at the motions in limine. Those are the motions that are essentially what we're talking about here, the evidence that either party wanted either admission, pre-admission, permission to be able to admit at trial, or they wanted to exclude it to prevent the other party from being able to offer it. That is, from my standpoint, interesting. Again, because of this review process, but also because those are the types of issues that are likely to be featured in the appeal. As we know, both parties have filed notices of appeal at this point, so it does look like that process is going to go forward. And so based on some of the public statements as well, primarily from Amber Heard's team, there has been sort of a suggestion, a preview of what some of those arguments might be, and the exclusion of evidence was certainly one of those. So I wanted to see what was it that they wanted to get in, that they felt they weren't allowed to, why they thought that wasn't fair, what sort of impact that would have had on the trial. These are all decisions, thought processes that the Court of Appeals is going to be going through as they review the arguments of the parties. So it was a chance to kind of get a preview of what that might be.
And a lot of people have talked about the Amber's lawyers did the rounds with the comparison with the UK verdict, and indeed this is one of those motions. What do you think about this being offered in some sort of appeal? Do you think that's an argument they might run?
Well, I mean, if I take them at face value on their statements, they seem to think that is a strong argument that they intend to feature on their appeal. Now, that particular issue, whether the UK judgment should have essentially precluded a trial in Virginia altogether, it is an issue that I followed at the time when they were litigating that. I did some fairly extensive legal research on that topic myself. And my conclusion was largely in line with Judge Azcarati's, that the law in Virginia simply does not favor that. My reading of the briefing was that, frankly, it was a pretty distorted attempt to present Virginia law as something that it simply wasn't. Where I disagreed with Judge Azcarati is, frankly, I thought it was sanctionable. She disagreed. That is her prerogative. She is the judge. But so, no, I don't have a whole lot of confidence that issue is going to have a lot of legs in the Court of Appeal. And this is kind of an interesting legal issue, just because it's based on this idea that once you have your bite at the apple, you shouldn't necessarily be allowed to go and relitigate over and over and over until you get the result that you want. There's a lot of reasons for that, fairness just being one of them, but also economy and efficiency and, use of the court time. There's a lot of people who are waiting for their day in court, and, so you don't necessarily, shouldn't be stepping in front of the line with like your eighth shot at trying to get your outcome. So there are good reasons for this philosophy in general, but at the same time, that has to be balanced against what is actually the process that is due on a particular claim. What is a full and fair adjudication on the merits of an issue? And so Virginia has adopted the rule, which is the minority rule in the United States at this point, but they continue to follow it for reasons that they have laid out in their own case law, that in order to invoke a judgment from a different jurisdiction or a different proceeding as preclusive against the party who is trying to assert it, that party would have to have been bound by that judgment themselves. And so what that's basically saying is that unless you two parties were the same parties in the other proceeding you're trying to rely on,
which they weren't.
Which they were not. They clearly were not. Amber Heard was clearly a witness in the UK. She was not in privity with the Sun. They had separate legal interests. She was not affected by the verdict in the UK. The Sun is not affected by the verdict in Virginia. So it simply doesn't meet that standard. It's pretty clear from that standpoint that wasn't going to be allowed, to go any further.
And that makes a lot of sense, because whilst the underlying issues, and there is a strong argument that she was the effective opponent in the UK trial, it was a very different claim against different parties, and as you say, different jurisdiction and so on. And so that's right. That was my reading of that code. She wasn't bound by that decision in any way at all. I mean, she wasn't even subject to the same disclosure obligations, which... And
I think that was a pretty key component in at least reading through Judge Azkaraty's ruling. I get the impression that was fairly significant for her. The fact that he did not have the opportunity to obtain and present so much of the evidence that ultimately did make it into the trial in Virginia, because he didn't have those discovery tools available to him. Another piece of it as well is just, we are sort of cousin jurisdictions when it comes to the law. We have, of course, a common background in the common law. Much of the U.S. process and even our substantive law is derived from the United Kingdom. But at the same time, we do have some fairly sharp distinctions in how things are handled in court, and some of the big ones that I think may have factored in there were the differences with how hearsay is handled in both proceedings. As I understood from following the UK trial, it appears that in the UK or in England and Wales, that hearsay is generally going to be admissible, but perhaps given less weight. Whereas in the United States, it is presumptively inadmissible unless it is subject to a certain exception that is laid out in the rules. And then obviously one of the biggest differences procedurally is the jury trial. Virginia, of course, is the birthplace of Thomas Jefferson, who wrote our Bill of Rights, and so are heavily influenced by that tradition, has specifically in their constitution that the right to a jury trial is fundamental. It's just something that is so highly prioritized in their jurisprudence that as well may have been a factor in that decision-making process. The fact that a jury trial was not going to be available in the proceeding in the UK, but it was something that both parties had a right to, and both parties demanded in the United States.
And that's interesting, because I've said a number of times that I think the UK trial should have been a jury trial, and the legislation phrases it in the negative, in that it will not be heard by a jury unless the court orders otherwise. So the presumption is that it's heard by a judge. But as the way many of these pieces of legislation are drafted, it suggests that it's possible that it could have been heard by a jury if so ordered. But obviously that didn't happen.
Is there a standard for what would cause it to be ordered, or is it just largely discretionary with the judge?
It seems to be discretionary with the judge making the court orders. And I think, not that I'm a specialist in defamation, maybe we'll bring Al Robert Shaw in next time and ask him. But I think it's probably rare that a jury would be hearing this sort of thing. It's normally going to the judge. And the way Al Robert Shaw describes it is that lawyers and judges are specifically told not to act as lawyers and judges, but to act as ordinary people in these trials. I say ordinary people with no disrespect whatsoever, contrary to what someone said in one of the comments the other day. What we mean is not legally trained. So if you know the law on something, sometimes it's quite easy to say this is wrong because this is against the law. But a member of the public might think, well, there's nothing wrong with that. But just because a member of the public, again, with respect, doesn't see something wrong with it, doesn't mean it's not wrong. Although, having said that, common sense very often prevails. So in these kind of cases, it really is a common sense approach. With defamation, it really is, what would a member of the public reasonably infer the meaning of something to be? So even if they are wrong, if it's clear to them what it means, even if it's wrong, that's the meaning. And is that, then you go on, is there damage, is there a defense, and so on. But I think for those watching in the States, particularly, who obviously know that this was heard by a jury and so on, perhaps imagine that this whole trial was played out only with the judge and not with the jury. Maybe we would have got exactly the same outcome. Maybe we wouldn't have. And you can then ask, what would you think about that? Would you prefer it with the jury? Would you prefer it with the judge? And I'm sure there'll be answers on both sides of that fence. I know some lawyers in the UK have said that it should all be heard by a judge always. But then we retain the jury as a default for Crown Court criminal trials here in England and Wales. And I say that's because if we want to punish somebody for something, we'd better be right. So we trust the jury still. It's the one bit of the Magna Carta, or Magna Carta, not the Magna Carta, that we really should hold dear, because that right to a jury trial. So I find that a really interesting way of thinking about it. So comparing those two judgments, so what do you think, if you've thought anything about the purported declaration by Jennifer Howell that turned up in these documents? And I say purported again, going back to the fact that it's not to be taken as fact and evidence, which again, with respect, as a lot of people will misunderstand, which is why I think it's important that we have you here to talk about it as well. So what, if anything, do you think about that?
Well, so that declaration, first off, it's not news in the sense that, as you pointed out, this all became public through the process of the appeal of the UK judgment. So it isn't particularly new information. For those of us who were watching the trial in Virginia and saw Jennifer Howell had been identified as a potential witness. We had seen this declaration, so we're obviously familiar with what it was that she was anticipated to testify to. But then we saw, as the trial unfolded and her deposition was played to the jury, that much of the substance that you see in that declaration did not get put forward at trial. And so I have a theory about this. I did a video on it during the trial process, because it does appear to be a misstep by Johnny Depp's legal team. Her statement, by our standards, is hearsay. She's reporting things that she was told by Whitney. She doesn't have personal knowledge of them. And so it's presumptively not information that she would just be allowed to testify to in a vacuum. But there are certain ways that could potentially become admissible. And the way that folks like myself had anticipated it was going to come in at evidence is as what's called a prior inconsistent statement. Because, of course, we saw Whitney testify to her version of the staircase incident, for example, and her own history with Amber, denying that Amber had perpetrated any violence against her. Statements that appear to be pretty directly contradicted by the statements that she had allegedly made to Jennifer Howell, according to this declaration. So it is potentially admissible, but there are foundational steps that the attorneys needed to go through in order to be able to do that. And the Virginia rule is very clear and very explicit about what those steps are. Whitney needed to be presented specifically with these contradictory statements and be given an opportunity to explain them. And then if she denied them or just otherwise took issue with what Jennifer Howell was claiming, then Jennifer Howell would have been able to testify to these statements, and it would have been up to the jury to then decide who is credible, who is not credible when it comes to these accounts.
Mm-hmm.
So obviously those steps didn't happen, and as a result, this information did not get into trial, did not get presented to the jury, and therefore didn't and couldn't have factored into any of their decision-making process. And so that's, I think, is a great example of what you're describing, or what I've been describing as kind of the review process of, seeing these documents unsealed, is kind of understanding, yes, this is the universe of what's out there, but we do have legal procedures and rules, evidentiary standards that have to be met. We have those for a reason. And so we can certainly debate the wisdom of those and whether those should be revised or do or don't function well. But at the end of the day, just being able to understand how all of this happened is a very important part of being able to evaluate, was that fair?
And it comes to a system of fairness as well, doesn't it? Because if there were arguments about these and they were not entered, then it was obviously decided they should be sealed. And it's a little bit like, as you alluded to, if you're putting something to a witness in cross-examination, then it's fair because you can then say that they were wrong. If you've not put that to them, you can't just suddenly blurt that out to a jury because they haven't had the opportunity to respond to it. And so what you're saying really is that these documents show the process behind all of the arguments towards the fairness of the trial. So, and that can swing both ways. And if anything in there was not right, then it comes out as a point of appeal. And I think that's what I think people can take away from this, is that this was a bit of the treasure trove of the legal arguments behind the scenes that ultimately was to determine and to ensure that this trial was fair, it was fairly heard, and that we can trust and rely on the verdict. I think that's ultimately what you're saying.
Yes, and I think that's particularly important in a case like this that has been so publicly dissected and gone over. There's just been so much information out there because these are high-profile individuals. They've been in the press for decades, and so there's a lot of information that people have about them, that people talk about, that influence their own personal thought processes and opinions about what they're seeing, but doesn't meet the standards to be treated as evidence in court. And so just given the fact that people were already aware of, for example, this particular declaration and these allegations, it is very important, I think, to understand why those were not ultimately elicited, why those weren't factored into the decision. Because I think a objective person could look at it and think, well, that should have come in, or it wasn't fair that didn't come in, or just whatever opinions people have about it. The fact that they knew about it already kind of makes it all that more important to then see how the legal process handles that type of information.
Absolutely. And again, I think a well done from everybody watching for getting hold of these documents so that everybody can look at them and hear about them. And of course, everyone will thank you for your service here on YouTube as well. I will bring your channel back on screen whilst you tell everybody what your plan is for your next video, where you're going next, what you are planning to talk about next on your channel here.
Yeah, well, so my channel is largely what I would call a deep dive channel. I like to look at fairly small details in depth. And so I've already given what I would consider like the 10,000 foot view of what is in these documents. There's a lot of discovery, litigation, lawyers quibbling over what's going to be produced, what is not. For those who are interested in seeing where an $8 million legal defense goes, that's going to be your money right there, because that is the volume of work that was produced just in the lead up to the trial. That's where the time is spent and the effort. So that from my standpoint is interesting, largely for that reason. Of course, there's the motions in limine that we've already discussed, and then documents relating to the post-trial motions, some things that look like they are framing issues for appeal, ways of kind of preserving arguments that may have been made during the sidebars or other parts of the trial process that weren't televised. I should add, incidentally, that what these documents don't include are those things like the transcripts of the trial, the transcripts of the sidebars, the full transcripts of the depositions, things like that. That information has been filed, and it is available for public inspection in the Virginia court. However, Virginia takes the position, or at least Fairfax County takes the position, that those documents are the property of the court reporter. So they will not make and provide copies of those. I personally, having researched this, do believe that they are wrong, but that is not a battle I am engaging in at this particular point in time. Although,
so people can physically turn up and look at them, but that's about it. Yes,
and that's something I kind of take a little bit of issue with, much in the way that I take a little bit of issue with the handling of the unsealed files. And part of the reason why I thought it was important to go out and make them public. I have spent most of my career in public defense. I represent people who do not have the financial means to be able to hire an attorney, to be able to, hire experts and investigators and things along those lines. But it is very fundamental to our society that everyone is equal under the law. Everyone is entitled to access to our justice systems. And so when you put a price on that access, that really goes a long way towards undercutting, what that access actually means. So if every individual person had to go pay $3,300 to look at these documents, you can imagine there will be far fewer eyes on them. And so it's a similar thing with these transcripts. There will be a cost, undoubtedly, even if ultimately copies are provided, that will be exorbitant. Worry about that when that time comes. But even as we sit here right now, the cost is, for those of us not in Virginia, getting on a plane, taking the time, having the opportunity to go there in person and look at those. And that's quite a barrier.
Yeah, I'd love to read them, but I'm not about to get on a plane and go and have a look. But I'm sure that I could sit and read them and have some, something to say about them. And a lot of people, just to finish on this, I'll give my thoughts, you give your thoughts. And a lot of people have sort of asked why, people have called it an obsession. Why the obsession with this trial? Now I'm going to correct it very slightly and say it's not an obsession with this trial. I think you've covered it in a lot of what you've just said. It's an obsession with the fact that justice should be public. I think justice is a publicly owned principle that everybody should hold dear. And if anyone disagrees with that, then put yourself in a position where you are behind closed doors and everything that happens you think is unfair and no one can look at it, no one can question it. And then you might think that you'd like someone to question it. So just recently we've done a video breaking down the allegations made in a letter. We didn't disclose the name of the law firm because that wouldn't be fair. We wouldn't call them out to disagree with us and that kind of thing. But we did that because it should be a public thing. I think everybody can have a view on that. And if it were to go to trial, it would be a public trial. Anybody could turn up. Lots of trials people do choose to turn up to. And I don't think this should be any different. But this trial being broadcast and about people, famous people that people know, people have heard of, somehow made them watch it, somehow made it mean something. But the underlying issues and the principles are always there, however big or small the trial might be. It might be a 3-hour hearing, but the principles might be exactly the same. That's for me, and you can call it, and people can call it an obsession to talk about it, to help people to understand it, because everything that I've ever learned about the law doesn't belong to me. It's a system. And I think you might echo the same thing, but your closing comments while I plug your channel once more.
Well, I would say that to the extent there's an obsession with this case, I think it's simply the fact that this case has brought a lot of issues to the forefront that have been kind of simmering in our cultural gestalt for some time. It's touched on a lot of, shall I say, sacred cows, taboos, things like male victims of domestic violence and the extent to which they are believed or not believed, the way that sexism plays a role in how we view male victims versus how we view female victims. Obviously, the media as well, how it handles allegations of this type of nature, the type of coverage that it provides. And so those things haven't gone away. Those are still important issues that a lot of people care very deeply about. So we continue to see them play out in this process as we learn more and more about what has happened leading up to this adjudication, and like I said before, kind of how the sausage is made with producing this verdict. The verdict is going to be reviewed by the higher court, and that's appropriate. Again, they have the right to have that process as well. So I expect this is going to continue to be an issue that people care about, people are interested in, and people want to know that the information they have is truthful and reliable.
I agree. And indeed, thanks to you, now the documents that were hidden and sealed that we can now look at, but remembering that they were hidden and sealed for a reason, but show the background of what was happening. So again, I'm sure everybody thanks you for that, and everybody will be interested in that. So with that, I will say, please make sure you go over to subscribe to Andrew if you would like to hear yet another perspective on lots of these issues. There's some great videos there. I'm a fan and a subscriber myself. And with that, I thank you all for watching. Please remember to hit the like button and subscribe here if you haven't already done so. Sometimes, by the way, YouTube unsubscribes you for some reason, and I don't know why it does that. Maybe it's a test that you resubscribe, but I remind you to subscribe partly for that reason. But with that, I thank you very much, Andrew, for your time. And for all of those of you watching, I thank you for your time. I thank you for watching.